There are some preliminary matters to be dealt with before any hearing can take place. As the living man, Stewart of Forwick, I am not election agent Stewart Allen Hill, the subject of the complaint, but I am able to act as that person. This is a special appearance of Stewart Allen Hill, the sole purpose of which is to challenge the jurisdiction of this court. Election agent Stewart Allen Hill now appears. As is my fundamental right, I, Stewart of Forwick, acting as election agent Stewart Allen Hill, am challenging the jurisdiction of the court on the basis that Orkney and Shetland are not part of Scotland. Nothing I say or do, or omit to say or do, may be construed as submitting to the jurisdiction of this court. I have advised the court of the conditions of this special appearance in my letter of the 25th of June, and there has been no objection to them, but it is clear from the hearing on the 14th of June before Sheriff Berry that the court intends to ignore them. As the court is aware, I, Stewart of Forwick, claim jurisdiction here. The Sheriff has no jurisdiction until it is proven to the court by the Procurator Fiscal. This is a public court, and for the benefit of both the court and the public, I shall read the contents of the 25th of June letter. The letter is addressed to the Clerk of the Court with a copy to the Procurator Fiscal. It reads: Dear Madam, citation reference KW 170000367, Procurator Fiscal versus Stewart Allen Hill. I, Stewart of Forwick, am dealing with the matter number KW 170000367, acting on behalf of electoral agent Stewart Allen Hill. As is my fundamental right, and as was agreed by the Sheriff at the first special appearance on the 30th of May 2018, I shall yet again be making a special appearance on the 25th of July 2018, solely in order to challenge the jurisdiction of this court on the basis that the Crown has never had the authority to make Orkney and Shetland part of Scotland or the United Kingdom. These are the conditions under which I shall make such special appearance on July the 25th, 2018. 1. Nothing I, Stewart of Forwick, may say or do may be construed as my submitting to the jurisdiction of the court. 2. There shall be no presumption of jurisdiction by the Sheriff or by any other party, either within the courtroom or outside it. 3. The Sheriff shall not wear a wig, for if he does, he is making a presumption of jurisdiction which has no force until proven by the Procurator Fiscal. 4. I shall appear as the living man, Stewart of Forwick, acting for the purposes of this hearing as electoral agent Stewart Allen Hill. 5. I shall be addressed as Stewart. 6. I shall take my place at the table facing the woman who claims to hold a valid accusation as Procurator Fiscal. 7. There shall be no further requirement for me to identify myself, for this paper is notice of my appearance in the specified capacity on behalf of electoral agent Stewart Allen Hill. 8. Every statement of fact made in the June 25th, 2018 Statement of True Facts shall be answered by the Procurator Fiscal, and if any such statement is not rebutted with specificity and in detail, the Procurator Fiscal shall be deemed to have admitted that statement as fact. Silence is acquiescence. 9. I wish to receive a copy of the recording of the proceedings which is to be made by the Clerk of the Court, an unedited copy of which shall be made available to me. 10. Any discussion in this hearing will be strictly limited to alleged territorial jurisdiction by Scotland or the United Kingdom over Orkney and Shetland, thereby excluding any other topics. 11. The argument as set out in the attached June the 25th, 2018 Statement of True Facts is complete in itself. 12. The duty of the Procurator Fiscal is to demonstrate with evidence territorial jurisdiction. In doing so, she shall restrict herself to specifically addressing only the statements in the attached June the 25th, 2018 Statement of True Facts. 13. Any discussion other than the items stated by the June 25th, 2018 Statement of True Facts is unacceptable and objectionable at this hearing and will be so identified by Steward of Forvik. 14. Sheriff Andrew Berry acted ultra vires at the 14th of June 2018 hearing, which has disqualified him from presiding in subsequent hearings. 15. A different and impartial sheriff is required to proceed in this matter. 16. Any violation of these conditions automatically terminates the hearing. 17. Termination of the hearing due to violation of these conditions causes findings being found against the Procurator Fiscal as per the attached order. If there are specific objections to numbers 1 to 17 above, those objections shall be raised in writing and sent by Royal Mail Sign-Force Service to Steward of Forvik at the above address, to be received not more than 14 days after your receipt of this letter. Failing to object within that time shall make the conditions irrevocable. Silence is acquiescence. Signed and sealed, the man commonly known as Stewart, sovereign without the states of Scotland or the United Kingdom. That letter was received by the court and by the Procurator Fiscal on the 27th of June, and no objections to its terms has been received. Its terms therefore stand. If the court has violated those terms, the order must be pronounced against the Procurator Fiscal. Before any violation is considered, the public shall be made aware of the contents of my statement of true facts referred to in the letter. It reads: 25th of June 2018 Statement of True Facts regarding a special appearance to be held on the 25th of July 2018. 1. I, Stewart, a living man of Forvik, Shetland, am acting as election agent Steward Alan Hill for the business before this venue. 2. Sue Ford, a living woman, is acting as the Procurator Fiscal for the Crown Office Procurator Fiscal Service. 3. An as yet unnamed living man or woman is acting as Sheriff for Grampian, Highlands and Islands Sheriff Court at Kirkwall, that is, Kirkwall Sheriff Court. 4. The Crown in Orkney and Shetland is defined as the successor to King James III of Scotland. 5. This special appearance to challenge jurisdiction is to be audio recorded by the Clerk of the Court. 6. The Procurator Fiscal has made a complaint number KW 170000367 against Stewart Alan Hill, alleging that Stewart Alan Hill did not submit a return of election expenses to the appropriate officer of the Electoral Commission. 7. The general election held in 2017 was for election to the purported constituency of Orkney and Shetland. This court's jurisdiction over Orkney is being challenged by Steward of Forvik as the living man acting on behalf of Stewart Alan Hill, but because the purported constituency includes both Orkney and Shetland, what follows necessarily also concerns Shetland. 8. I, Steward of Forvik, a living man over the age of 18, do hereby advise this Sheriff Court of the following facts about which I have first-hand knowledge through research and/or experience. First, sovereignty. Paragraph 9. The feudal system of land ownership was in force in Scotland before 1468 up to 2004, when the abolition of feudal tenure, etc. (Scotland) close brackets, Act 2000 came into force. 10. Volume 18, paragraph 43 of the Laws of Scotland, Stair Memorial Encyclopedia, 1993 edition, henceforth referred to as Stair, states: A. From these beginnings, feudalism developed steadily, reaching its classical period in the 11th and 12th centuries. 11. As to sovereignty over Scotland, Volume 18, paragraph 42 of Stair states: A. Thus, in feudalism, land ownership and sovereignty coincided, so that the Crown's sovereignty over Scotland and its dominium eminens, its ultimate tenurial superiority, were the same thing, were identical concepts. Since sovereignty involved jurisdiction, land ownership implied jurisdiction, so that the royal courts could dispense justice because the Crown was the ultimate superior, and every subordinate owner of land likewise had the right to hold courts, and in fact did so. I'm going to repeat the bulk of that paragraph because it's vitally important. It reads: Thus, in feudalism, land ownership and sovereignty coincided, so that the Crown's sovereignty over Scotland and its dominium eminens, its ultimate tenurial superiority, were the same thing, were identical concepts. Since sovereignty involved jurisdiction, land ownership implied jurisdiction, so that the royal courts could dispense justice because the Crown was the ultimate superior. Number 12. 11a above does not explicitly identify dominium eminens with allodial land ownership, but Volume 18, paragraph 47 of Stair further states: A. The dominium eminens, or ultimate superiority of the Crown, is allodial because not held of a higher lord except of God. 13. Thus, the conclusion is that the ownership of the allodial title by the Crown is the fundamental requirement for sovereignty, jurisdiction, and the ability of the royal courts, or any other courts, to dispense justice in Scotland. 14. In the feudal system, it is impossible for anyone apart from the Crown to own a land allodially, because, by the definition at 11a, if they did, they would be sovereign of that land. 15. All other aspects of sovereignty, such as prerogative, are inferior to that conferred by allodial title. All such aspects rely on the courts for enforcement, the authority for which is held by the owner of the allodial title. That describes the situation in Scotland. Now, Orkney and Shetland. Paragraph 16. Stair, Volume 18, paragraph 47 states, in relation to land in Scotland: A. But to this rule that all land is feudal, there are certain exceptions. The first is feudal land in Orkney and Shetland, which is, as the name indicates, allodial. 17. Green's Encyclopedia in Volume 15, paragraph 702 says: A. All lands in Orkney and Shetland remain feudal. 18. Those lands are in the hands of the feudal owners. The Crown, as successor to James III of Scotland, has no claim to the allodial title of Orkney and Shetland. 19. Thus, because the Crown has never owned the allodial title, Orkney and Shetland could never have legitimately become part of Scotland or the United Kingdom, and are outside the jurisdiction of Scottish courts. Those courts have no ability to dispense justice in Orkney and Shetland. This concludes the argument, but a further point needs to be clarified, and that is about feudalisation. My paragraph 20. In the above reference at 17a above, the full quotation reads: A. All lands in Orkney and Shetland remain feudal, excepting those such as have been feudalised by charter emanating directly from the Crown, or indirectly through earldom or bishopric title. 21. Historically speaking, feudalisation allegedly converted allodial titles to feudal titles. It's a term used by historians and lawyers to explain away the anomaly of Orkney and Shetland. It's said to have been used by those Scottish lords to whom the Crown had granted a feudal charter. Those lords would induce feudal landowners to relinquish their allodial title in exchange for a feudal title. The landowners thus purportedly became a vassal of the lord, but then had a piece of paper with some value in Scots law. However, feudal titles can only emanate from the Crown, and it is axiomatic that the Crown must have the allodial title before it can issue a feudal charter. Since this was never the case in Orkney and Shetland, the lords granting those feudal titles to feudal landowners did not have a valid feudal charter from the king to enable them to issue valid feudal titles of their own. 22. On feudalisation, Stair in volume 24, paragraph 307 says, "There can be no proper feudal holding which does not flow from the Crown." 23. Nemo dat quod non habet. No one can give what he does not have. 24. The Crown could not give what it did not have, unless land was first surrendered by a landowner to the Crown, of which there are no examples in the literature. The Crown did not have the allodial title for it to be able to grant a feudal charter in Orkney and Shetland. Feudalisation was, and still is, an impossibility in Orkney and Shetland. 25. Any reference to feudalisation as regards Orkney and Shetland in statement 20a above can be ignored. All land in Orkney and Shetland remains feudal, in other words, allodial. 26. The Crown's sovereignty in Scotland was, until 2004, defined by its ownership of allodial title. It has never had the allodial title, the essential foundational authority for it to hold courts and dispense justice in either Orkney or Shetland. 27. The Crown has never had and never could have had sovereignty over Orkney and Shetland. 28. Not only is the Crown's jurisdiction rejected in Orkney and Shetland, conversely, jurisdiction is claimed by the sovereign people of Orkney and Shetland. 29. Orkney and Shetland, being totally feudal, are owned by the legitimate allodial landowners of those islands. 30. Statement 11a above proves that those landowners have innate sovereignty, jurisdiction, and the ability to dispense justice for themselves. They have no lord or superior except God. 31. I, Stewart of Forvik, owning my own land, am a sovereign individual in Shetland outside the jurisdiction of Scottish courts. 32. I, Stewart of Forvik, claim jurisdiction in this court. The words of a sovereign need no corroboration. Signed and sealed by Stewart of Forvik and dated the 25th day of June 2018. Attached to the above statement of true facts were the supporting authorities numbered as the footnotes. It is now time to consider whether the court has complied with the conditions of this special appearance. At the time of this recording, I'm not aware whether the conditions will have been met or not. The relevant questions are: 1. Has there been a presumption of jurisdiction by the sheriff or anyone else? 2. Is the sheriff wearing a wig? 3. Am I addressed as Stewart? 4. Have I been allowed to take my place at the table? 5. Have I been required to identify myself? 6. Is Sheriff Andrew Berry presiding? And finally, 7. Are these proceedings being recorded? If any of the above questions is answered in the positive, the terms of my appearance have been violated, and the order enclosed with the letter shall be signed by the Sheriff, stamped by the clerk forthwith, and a copy given to me. That will be the end of the matter. If the conditions have been met, or are now being complied with, it is now up to the Procurator Fiscal to show proof that the Crown has or had the allodial title necessary for its sovereignty and the ability to hold courts in Orkney and Shetland. If the Procurator Fiscal is unable to show such proof, the order shall be signed, stamped, and a copy given to me as just described. I now require the Sheriff to either sign the order if my conditions remain unmet, or, if they are met, to ask the Procurator Fiscal to show proof of the court's jurisdiction. Thank you.